Hello, my name is Thomas Nägele and I'm an attorney at law from Liechtenstein, the small country bordering Switzerland and Austria in the heart of Europe. I had the honor to give a keynote speech at the first ever XiXOIO conference end of 2018, and my topic back then was the draft legislation of Liechtenstein, the Liechtenstein Blockchain Act. This Blockchain Act is now in force since 1st of January 2020, and the organizers of the conference asked me to give a regulation update and an outlook of what might be coming on a European level, the so-called Market in Crypto Assets Regulation, MIKA. And so what I want to do now is just to refresh your minds a little bit, for the ones who didn't hear my presentation back then. I want to give you a brief overview of that regulation because it's a very interesting concept, and it also already served as a blueprint for other legislators and jurisdictions when they think about regulating in the area of blockchain and DLT. And it all starts with that we don't call the Blockchain Act actually blockchain, or the title of the act is TVTG, and where we refer to the technology as trusted technology or trusted technologies. So you don't find blockchain or DLT in the legislation, and you don't find any classification approach. Why is that the case? Because we wanted to have a very comprehensive approach where we have then actually the legal framework for tokenization of assets. So we don't have a classification approach. We only define the token from a legal perspective, and if something falls under the securities laws or not, that's a different question we don't ask with the Blockchain Act. I will come to that when we talk about what the European Commission proposed with their legislation. And the main concept of the Liechtenstein Blockchain Act is actually the token container model. That's the core principle. So you have in the center of all of that, you have a legal definition of a token. The token is a new object in our legal system, which we define as a piece of information on a TT system, which stands for blockchain or DLT, which can represent rights. We'll come to that in a minute, and is assigned to one or more TT identifiers. So this serves actually as the legal framework for tokenization of assets. And what does that mean? If you want to tokenize an asset, it's more than just the securities, for example, where you can say, okay, if I want to be a shareholder of a company, I can actually tokenize the shares. It's much more than that, and it's a very, very flexible approach Liechtenstein took here. So we said, let's define the token from a legal perspective, and then let the token represent whatever right we have in our legal system. Basically, every right, there are some limitations for sure. But the concept is you start with preparing the token. And what do I mean with preparing the token and the needed token functions? You have to prepare it from a technological point of view, because for every right you're representing, there might be some additional functions needed. So for example, if you tokenize your shareholder rights, you might need burning functions. If, for example, you lose your access to your token, and then you have to burn the token and issue a new one. So prepare the token from a technological point of view. That's why I used that picture with the braces you see up here. And then as a second step, you have to define the right. So for example, if you want to tokenize the ownership rights of a physical object like a diamond, in this example here, you define the ownership right, and then you will let the token represent that right. How is that done? This really depends on the right you want to be represented with the token. So for example, with securities, there's a specific way of doing that, and we amended our Corporate Act to do that, so there's a new registry. But for example, if you want to tokenize the ownership right of a physical object, then you have to have a different way of how to make the link between the physical object and the token. And this is actually this gives you a lot of flexibility, because it's not fixed to one or another solution, as you found it in other jurisdictions where they only, for example, amended their laws to make digital securities possible. And fourth, what you have to do is, or what you actually get out of that, is that if you transfer a token, also the represented right is transferred. And what does that mean? You then are able to use blockchain or DLT technology to let token represent assets, and you can transfer these assets easily with only the use of technology, and you have legally enforceable claims. And this is a very, very powerful tool then. That's what I always say. It's like the enforcement layer if you talk to technicians. So the token container model allows you to tokenize assets, and it's not limited, as I said, to securities, for example. You can also tokenize commodities, physical objects, intellectual property or utility, or others. And that's the right part of that picture, the rights you can represent. This is just some examples. And on the other side, now you have to link to the rights represented, and on the other side, you also have to link to the individuals. And in our piece of legislation, we do it via the TT key and TT identifier, where TT key stands for the private key and the TT identifier for the address. And with that concept, you have the token in the middle, you have the rights on the right side, and on the left side you have the link to the individuals. And this allows you to actually build a lot of products and services with actually this legal framework we have. And what's so different to a lot of other approaches is that you now can use trusted technologies to easily transfer a token from party A to party B. But our legal framework will actually give you the enforceability of your token transfers, and not only for the token, but also for the represented rights. So you will end up with the legal certainty that if you transfer a token, you also transfer the represented right. If you want to sum up that on one page, it's actually a very comprehensive piece of legislation, as I said, with a lot of rules and amendments and new ways of how to transfer things. There are also amendments of the Corporate Act and our civil law. But on one page, we have in the center the definition of a token, as I said. The functions of tokens are similar to the functions you have with securities, so legitimization, liberation, and transportation. We talked briefly about the relationship model, TT keys and identifiers, where you actually have the link to the individuals. So you have the token in the center, and they have the link to the individuals, to the persons acting. And on the other side, if you use that the Token and Trusted Technology Service Providers Act, or TVTG, if you dispose over a token, you also dispose over the right, and the right will be transferred if you transfer a token. And this is actually the legal framework for tokenization of assets of quite a lot of different rights. You can actually a lot of rights you can imagine. And how is that done? As I said, it's done via representation of rights. So you have the asset, you let the asset, you define a right of the asset, and then let the token represent that right. For some cases, we introduced new service providers. So if you want to provide services in that area, you need to get registered with our financial market authority first. This is to protect for sure users and customers, and to also provide a certain quality when you provide services in that area. Coming to the market in crypto assets regulation now. This is a proposed regulation, so this is not yet into force, and this is not the final version of it. This was actually published by the European Commission in September 2020. This was published as a digital finance strategy with not only the MIKA, there was also a pilot regime published for markets infrastructure on DLT, which is also a very, very, very interesting piece of legislation. If you follow me on LinkedIn, you will find the link to my Medium article about the secondary market for security token, which is covering exactly the challenges we have on our capital markets when you want to use DLT or blockchain technologies. And you find all of that text here with that link or behind the QR code. And so what actually MIKA proposed, and that is something which is pretty clear, because Liechtenstein is part of the European Economic Area. If this regulation will come into force, this also has an impact on our TVTG. So some parts of our TVTG will be actually we have to amend them, but I will show you where this MIKA is actually giving us or is bringing challenges, and where it solves a lot of problems. And I want to give you a brief overview of MIKA and the opportunity there as well. So if you have MIKA, the market in crypto assets, we call that token. They have categories with that draft. And one category is the essence reference token, another one is utility, another one is e-money token, and then proposed is a catch-all definition. That's not what I think is very interesting, the classification. But I think what is really very interesting is that with MIKA, the European Commission also said the MIKA is covering the crypto assets part. So it's not covering the securities part. So if you have, for example, if you have a security and you let the token represent that security, that doesn't change that something is a security. And that's what I always said, and Liechtenstein also said with the Token Act or the Liechtenstein Blockchain Act, that security laws are actually fine, and for most of the challenges we have suitable answers within the financial market laws. So what with that MIKA also is proposed is an amendment of MiFID II. The definition of financial instruments, and the idea there is that it is amended in a way that financial instruments, as it states here, means those instruments specified in section C of Annex 1, and now it should be extended to including such instruments issued by means of distributed ledger technology. And what does that mean? In the end, you can issue securities and you can deal with securities and use this technology, and just the fact that you use distributed ledger technology doesn't change the way how you have to deal from a regulatory point of view with financial instruments, which gives you actually clarity. Now you know that on the one hand you have the market in crypto assets or the crypto assets, and on the other hand you have financial instruments which are issued by means of distributed ledger technologies. And if you now want to compare TVTG and MIKA, so the Liechtenstein regulation, and what is proposed on the European Union level, we cannot go into much detail, but I tried to list on the left side the service providers of MIKA, and on the right side the service providers of the TVTG. And what you see here is that the level of regulation is quite similar in my opinion. And there are some service providers on both ends where you don't have an equivalent on the other side. So therefore, I think it makes sense if this regulation comes into force that Liechtenstein amends the TVTG. What is interesting is that there might be a simplified registration or licensing procedure for service providers which are already providing services based on national law. So, for example, if you are already registered under the Liechtenstein TVTG and MIKA comes into force, and this comes into force in a way as it is available now, the draft, that there might be a simplified procedure that you then afterwards, and that's the interesting part, I think, and that's the value you get here, because if you have MIKA in force, within the European Union and the European Economic Area, it will allow you to passport your services again. So what we know from the banking world, for example, if you are a bank in the European Union and you want to provide your services in another member state, you can easily passport your services, which is a quite easy process in comparison to deal with every local regulation. And this will actually allow you to passport your services to the European single market. And with MIKA, the idea is the same, that you get actually access to the European single market via passporting, and this will allow, for example, for our Liechtenstein service providers also to passport the services to the member states. So key takeaways of today's presentation. The token container model is the main concept behind the Liechtenstein TVTG, as I said, which is in force on 1st of January 2020. What you will get out of that is legal certainty, because then you have like legal enforceable claims, and there's more to come with MIKA on a European Union level. And I briefly touched on a lot of other very interesting topics which are happening on a European Union level. For example, the pilot regime, the secondary market for security tokens, and I have some executive summaries also here with links. And if you want to follow me on LinkedIn, I do publish quite a lot of times about developments in the DLT blockchain space, and specifically also about MIKA and DLT and what's happening on a European level. That was it from my side. I was asked to do it in 20 minutes. I am happy if you have any questions, you can reach me via LinkedIn or via my email address. And I was honored to give you this regulation update, and I hope you have a nice conference. Thank you very much.